For pronouncement of judgment, item 44.
The appeal fails. Develop. May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 27 of today's list, fresh admission. Kindly pass over the matter and let the matter be listed on 7 January 2025, Lordship.
Why?
Lordship, my auntie is very serious and right now I am to leave for Tezpur. That's why.
The disciplinary proceedings against the tribunal
Yes,
to
Lord.
interfere.
Yes.
What's wrong in the order of the tribunal?
27.
Wrong, Lordship, natural justice and reasonable opportunity have been from which I have been deprived of. That's why. And copy of the complaint has not
There is
been
no
furnished.
procedural limit. There is a recording of the tribunal.
Lordship, frequently I just.
Monday, not Monday.
Obliged, Lordship, obliged.
For the item number 40, my lord, the hearing item, I've taken the consent of the other side, my lord. I apologize, my lord. I could not give the mention slip. Some difficulty today, my lord. Can it be in the second week of December?
Adjourn.
Second week of December.
Adjourn.
I'm obliged, my lord.
May I please also, my lord, I beg to mention item number 22, my lord, with the consent of the other side, my lord.
22.
My lord. It may be taken up after a week, my lord.
Adjourn.
Obliged, my lord.
Item 40, there is the interim that may continue.
My lord, is it 43? My friend is mentioning
Which item number?
43.
There is no mention about 43.
Okay.
Wait,
My
please,
lord,
I beg to mention item number 28. Inadvertently, some pages of an annexure were left out.
Adjourn.
I'm seeking leave to file an additional affidavit. Please.
There's no need.
May please, Your Lordship. Lordship, I'd like to mention item number 36 to 39 of today's list, Lordship. Because we had submitted a slip yesterday, senior counsel, Mr.
Adjourn.
Lordship.
May I please, Your Lordship? I'd like to mention item number 16 of the positive today.
16.
16. Date may be fixed, Lordship. 17 or 19 may be fixed, Lordship.
Adjourn.
Develop.
Yes.
I am for the other side, Lordship, in this case.
My lord, I beg to mention for item number 7, my lord. My lord, may kindly adjourn it and fix that after 3 weeks, my lord.
7 review petition.
Yes, my lord.
What is this in the review?
My lord, it is something has to be added here, my lord, because the drafting is, means not a proper way it is drafted. That's why, my lord.
Adjourn.
Obliged, my lord.
May please, yes, Your Lord. Lordship, item 29, we have already circulated 29. We
20.
have circulated the adjournment slip, Your Lordship.
Adjourn.
Deeply obliged.
my lord,
May I please, Your Lordship?
item 43, the other side has said that they want to adjourn the matter. So, my lord, I just thought that if they are seeking adjournment, if your lordships can give us a convenient date,
Ma'am, there is no mention.
or very well, my lord.
If you want an adjournment,
No, I don't. The other side had mentioned to us. We are well to do with the case.
today there is no mention.
May I please, Your Lordship?
Yes.
I beg to mention item number 15. It may be possible for the date.
15. Yes, why?
And this for, we have challenged the B.Ed certificate of the private respondent.
You will challenge the,
B.Ed certificate of the private respondent.
let us, let the number comes.
Any request? Daily list for this item 1.
1 and 2, my lord, it's arising out of same appeal, my lord, or same order, my lord.
Lordship,
My lord, in item 2, my lord, so far the respondent 4, 5, 567, my lord. It is already, my lord, we have filed Dusty, Dusty affidavit file, my lord, with file, my lord. Item number 2, my lord.
So service is complete, you mean to say that?
Yes, and in item number 2, my lord, the same respondent in item number 1 also.
I think so far, I think one is concerned, Lordship. We have also served upon 4 and 6 to Dusty. Lordship, my lord, sometime we'll be filing affidavit of service, Lordship.
You are appearing on behalf of all the respondents or what?
Lordship,
No, he is appealant, my lord.
I am petitioner, Lordship.
You are the petitioner.
Yes, Lordship.
Appellant, my lord. He is appellant.
Appeal and
He
Lordship.
is the appellant and the respondents are?
My lord, in his case, my lord, I am one of the respondent, my lord.
You are for-
One of the private respondent, my lord.
And what about the others?
Others are complete, Lordship, except 4 and 6. In 4 and 6, we have taken Dusty. It's complete. We need some time to file affidavit of service, Lordship. We'll file it, Lordship.
So far, 4 and 6, my lord, it's the same respondent in my writ appeal, my lord, item 2, my lord. In this case, we have taken step, my lord, and Dusty service taken, my lord, we have filed affidavit, my lord.
That is,
Same-
that is, he
same.
has an
You have
appeal.
already filed, let them file their.
Yes.
After a week.
Yes, obliged, Lordship.
Item 3 and 4.
Yes, my lord.
Whether the director has passed the order.
My lord, director has, that order has already been passed, my lord. Now it is pending for verification of area salary. We have received the proposal from the inspector of schools, my lord. It is under verification at the level of directorate level, my lord.
How much time will it take?
Another 4 weeks, my lord, because we have to submit it to the government, my lord, for sanction. Once it is verified, my lord, we will submit it to the government, my lord.
But in fact, this regularization order has already been passed.
Yes, my lord, that has been passed.
And director was supposed to pass a necessary order for what?
Now, my lord, regulation has been done, my lord. Inspector has passed the regulation order after getting sanction from the government, my lord. Now we have to pay the salary for that period, my lord.
Who will pay this salary?
Salary will pay by the director, my lord.
On the last occasion also, the same, statement was given.
That time we have sought from area salary proposal from the inspector of schools. Now we have received it, my lord, and it is
Council for the petitioner has submitted that the statement regarding the areas of the salary of the petitioners have been received by the director. As school education department, and the arrears, after verification of the same, the arrears would be paid to the petitioners within a period of 4 weeks.
4 weeks, my lord.
Positively within a period of 4 weeks from today. List after 4 weeks.
Obliged, Lord.
Item 5.
We have taken steps in respect of all the parties. We have filed affidavit also showing Dusty service. Sericulture
We'll get the notices awaited. The
Sericulture department is there, my lord.
number 126 has not been received. You have filed an additional
Government
affidavit?
departments are there, my lord. I think the Directorate of Sericulture, they can take into their file. Directorate of Sericulture is there, they can appear, my lord.
So 126, the. Yes, ma'am.
I can appear for 1, 3 and 6.
You are appearing for 1, 3 and 6. And what about this superintendent archaeologist? This notice has already been served upon all the respondents.
Yes, we have served.
As per the office report. Notice sent to the respondent number 126 has not been served till date. However, an additional affidavit, is filed on behalf of the petitioner with the proof of service of notice through registered post upon the respondent number 6, upon all the respondents. Full stop. In such circumstances, we deem it appropriate to read the service of notice upon the respondent complete. list this matter for admission after 2 weeks.
Item 6. May I please, your lordship? My lord,
Respondent number 13 is expired.
yes, your lord.
You have to take steps.
Lordship, we are not intending to substitute the legal heirs here
Why?
because we were challenging the appointment of the aspirant number 13. The legal heirs,
How is appointment, how will you get the relief? Depending unless legal representatives may have some interest in protecting his appointment. Maybe some benefits out of that appointment, they may be able to get.
okay, in that case, my lord, we implement the
Okay, as per the Logima Court, Logima Court's order dated 14/11/2024. The respondent number 13 has expired. When it concept for the applicant raised for and granted time to bring on record the legal representative of the respondent number 1, respondent number 13. Time period for is granted. Necessary steps be taken. The application for bringing on the legal representatives of respondent number 13 be filed within a period of
1 week.
after collecting the details,
Lordship, I will need some time, 10 days at least.
2 weeks.
2 weeks. Obliged, Lordship. Item 8.
I apologize, your lordship. I shall take steps, your lordship. I failed to take steps, your lordship.
When it concept. There is some more time to take steps for service of notice upon the respondent number
4 and 5, your lordship.
registered post and daily. Time period for is granted. Necessary steps be. In the consent for the applicant may take necessary steps within a period of 10 days from today. On taking such steps, the notices be issued to the respondent number 4 and 5. Respondent 4 weeks thereafter.
I'm deeply obliged, your lordship.
Item 9. May I please, Lordship, this matter has become infectious, my lord. We have already disposed of. This matter has become infectious, man.
When the consent has submitted that this contempt petition has become infectious, this means that infectious.
Obliged, my lord. Item 10. My lord, this matter may be taken up at 2, my lord. My senior is on legs. My lord, kindly accommodate me.
The order you are complaining for.
My lord, page 100.
100.
And relevant part, my lord, page 103.
100. The order is.
Order is, it starts from page 100, my lord, and
Is 100.
the relevant portion, my lord, page 103. Last para, my lord.
Having heard the Vancouver of the judgment first. So now.
So, my lord, it was directed to ascertain first whether the land belongs to PRF or RF, my lord. Without ascertaining, my lord, they are threatening the persons, my lord, to.
How they are threatening?
My lord, they visited the place, my lord, and my lord, they asked the people, my lord, to vacate the land within 15 days. My lord, I have stated in paragraph 15.
Stated is also the different what is.
There is no.
Whether they have issued any notice.
No, my lord, there is no.
Whether without ascertaining them, whether they have proceeded further.
Their officials, my lord, they are frequently visiting,
That can't be simply on the basis of this statement.
but there is no written, my lord, notice.
Ultimately, you have to, if there is no written notice, then you can't say that they are going to dispossess you without ascertaining whether this land is reserve forest or proposed reserve forest. That can't be the case, sir.
My lord, at this point, my
That
lord,
may be one of the tactics to, that the contempt petition is pending, don't proceed further. That is
no, my
what
lord, we have communicated the order.
Then unless some strict proof is there, they have violated, willfully disobeyed this order. Otherwise, we are not going to issue contempt.
My lord, kindly take up at 2, my lord. Mr. Amir Mahmood
To,
at 2 p.m. My lord, kindly accommodate. He is on legs, my lord, at court number.
also for the time being.
Yes, my lord. Obliged.
Item 11.
This is a contempt petition. The lordship find a order at page 17 in passing writ appeal 61 of 2023. And cooperative portion page 18, my.
They have not made the payment.
Not paid, my lord. They have flouted, my lord.
This returnable,
Obligation.
returnable 4 weeks.
Obligation.
Item 12.
Lordship, there's a delay of 63 days. Others that had not entered appearance, so we have taken drastic steps also on 11/11. We have filed one additional affidavit to that effect, Your Lordship.
That notice has been served.
Yes, Your Lordship, on 14/9/2024 itself. 24/9. We have annexed it.
Respondent, the notice have been served upon respondent number 4 and 5.
Yes, my lord.
But
None has entered appearance.
governing body
Yes, Your Lordship, and the
and
principal, my lord. This is for the second time we have taken
So
steps. my-
who has received this notice? Principal.
Principal Bonga College, wherein the petitioner is serving, appellant is serving.
Yeah.
63 days delay, Your Lordship, kind enough to condone it.
But who is appearing for the other respondents?
Official respondents in the higher
Because
education.
I am appearing for 1 and 2. 1 and 2, what about 3?
3-2,
This is finance fellow.
finance.
Who is appearing for finance?
Namata koi thya? Nayak koi nahi.
Who is appearing for finance?
We go or K Nayak appear generally.
8. Kali hai jo pe.
Grounds of delay we have stated in.
Just a minute. Just- So the applicant was suffering from jaundice.
Jaundice, my lord.
Any report?
Lordship, we took local treatment, my lord.
Local treatment?
Yes,
What do you-
we wear some mala, your lordship, in order to cure jaundice.
And
Local treatment,
by
it's,
that you have been cured.
no, it's cured. It's lordship, it's prevalent here in Assam, my lord.
Is some medicine from some doctor.
Lordship, he said, lordship, as per the instruction of my client, he took local treatment And thereafter, Lordship, he come down to Guwahati in order to engage his counsel.
Ask your client or you also circulate this local treatment to all.
Lordship, it's
women.
prevalent here. I can vouch for it, my lord. It's prevalent. We wear mala, your lordship. Some people give like
That is everywhere, that is
Lordship.
prevailing.
my lord.
But that, only on account of that, jaundice can't be cured. Some medicine is required for that.
Lordship, he, as per my instruction, he hasn't taken any other medicine except that, your lordship. For end of justice, your lordship,
Some excuse कोई ढंग का तो देते,
my lord.
थोड़ा सा ढंग का excuse तो देते.
Lordship, I leave it to lordship discretion, but lordship,
As per the office report, the notice of application of the respondent number 4 and 5 has not been served till date, however. And thus an affidavit is filed on behalf of the applicant stating that the submitting the proof that the notice on behalf of the respondent number 4 and 5 has been received personally by the principal Bogoingaon, College Bogoingaon. The notices upon the respondent number 1 to 3 have already been served. Stop. This IA is filed under section 5 of the Limitation Act with a prayer to condone the delay of 63 days in filing the connected appeal. It is stated in the application that on account of illness, the applicant, the applicant has failed to file the appeal within the limitation prescribed. To stop. No counter to the application is filed on behalf of the respondent number 1, 2, 3, and even none is appearing on behalf of the respondent number 4 and 5. Having heard the learned counsel of the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 63 days in filing the connected appeal. Hence, the IA is allowed delay of 63 days condone. Registry is directed to register the connected writ appeal and list for admission before test court after 4 weeks.
Item 13.
Fresh,
Delay of 13 days
Fresh,
notice has to
fresh.
go.
it's a fresh matter.
Yes, ma'am. Notice.
Notice.
Well, on respondent number 1, I'll take Dusty, man. He's a private man.
All the respondents you may take. Registered daily. Yes, next.
Item 14.
Notice.
Notice.
No.
Weeks.
Oblige.
Registered daily.
Oblige.
Daily list for admission. Item 15.
We have challenged the BEd certificate of the private respondent, my lord. On the ground that it was at that point of time when he procured the degree, my lord, the
It was not recognized
And
by
not-
the NCET,
by the NCT and
but the NCT has granted them permission to continue with the course.
yes, without recognition.
Without recognition, yes.
Yes.
Obviously, the Supreme Court judgment is very clear. This court judgment is also very clear on this.
Yes, that is clear.
What remains?
The
Show us any other ground. Is
But
that
the
the only ground?
legal position is that, my lord, it has to be recognized first, thereafter affiliation has to be
Legal
taken.
position and
But the affiliation,
for the very same college, this court has already ruled. Very same college.
yes,
Then in Kamdev Sharma,
yes.
relying on this Supreme Court judgment,
But the inspection report, my lord, page 165 of the college, my lord says that it was During that period when he procured the degree, my lord, it was not,
You're aware of
yeah.
view taken by this court.
Mm.
Even though if that recognition was not there at the particular time, but later on it was granted, it will relate back to that day.
Mm.
Is there? So,
At least notice may go, my lord.
notice for at least convince us, will even grant stay even, convince us.
The factual aspects are different, but the legal aspect is, my lord, the
Legal aspect on legal aspect also, then there is a Supreme Court judgment. This court has also ruled. it. Will declare the order.
Item 17.
May it please your lordship. One of the appellant here is the ward commissioner. He participated in the minor cell where the State Finance Commission has recommended some amounts grants in aid to the local bodies, municipalities. The submission before the learned single judge was this: there should be a recommendation for the Finance Commission for the utilization of the fund by the local bodies or through the guidelines. The guidelines which shows, but the learned single judge held that when there is no guidelines, it is the municipality board where under section
There
58,
is no guidelines, then
when there is no recommendation, the learned single judge held when there is no recommendation, but your lordship will find the State Finance Commission, IA was filed for making the State Finance Commission a party. The learned single judge first disposed of the writ petition, then on the basis of the writ petition has disposed of the miscase, saying that because so the recommendation that should have been coming from the Finance Commission was not considered.
what's wrong in that? Once the all the members sit together and they have decided that we'll.
My lord,
distribute
here
the fund
before
equally
the
each and every one, what's wrong in that?
before that, because under 58 also, my lord, that 58 where it says all such sums as the state government may sanction as granting aid from time to time, subject to such terms and conditions as may be specified. And my lord, the guidelines which was formulated by the Finance Commission at page 60, it says in the ratio of population 90:10. So my lord, the population, it is where the guidelines that your lordship may just consider that page 60. Page 60, my lord, the first, my lord.
Yes.
The guidelines starts at page 56
Yes.
and the page 60 is the relevant.
Read.
For the urban local bodies other than million plus cities, the grant shall be distributed to each urban local bodies on the basis of accepted recommendation of the latest State Finance Commission, suitably modified to accommodate the cantonment boards. In case of non-availability of State Finance Commission recommendation for the distribution of within a particular category, the allocation should be on the basis of population and area in the ratio of 90:10. The state.
Ultimately, these are only guidelines.
My lord, then my lord, if there is no recommendations, these guidelines will come. And my lord, for the recommendations, we wanted to make the State Finance Commission a party. Under Article 280, your lordship will find where the 280 deals with Finance Commission, my lord. And my lord, where it says, your lordship will find 280C. It is the duty of 280 starts with the Finance Commission, and C says the measures needed to augment the consolidated fund of a state to supplement the resources of the municipality in the state on the basis of the recommendation made by the Finance Commission of the state. At least the learned single judge could have waited for the State Finance Commission, whether they would say that there is a recommendation or not. Your lordship may look into my lord, IS order that is at page 77, 77, my lord. Your lordship will find where in the IA, the learned single judge held, in view of the page 77D, in view of the order passed in the court today, in the connected writ petition being such and such, no further order is called for this interlocutory application. The interlocutory applications accordingly stand closed. So, my lord,
The final order passed in.
but my lord, at least the learned single judge could have, because this is in basis of the prayer made by us in the IA to make the State Finance Commission a party and at least to call for their recommendations.
Why the state government was?
State government, no, Finance Commission.
Finance Commission was necessary party for that?
It was necessary party because State Finance Commission recommendation is guided to the municipality.
Should have made it
My lord,
on the very first day.
My lord, but the matter is not decided on the basis of making of necessary. But it was pending, my lord. My lord,
You should have made it in party at the
but before the judgment was passed, my lord, that
exercise discretionary jurisdiction.
and
we found
before
that,
the
there
minutes,
is
my lord,
Not much arbitrariness in that. Once the whole.
my lord, because the
municipal board-
before the minutes,
Before the municipal board, members of the municipal board sit together, and they have decided that the.
my lord, your lordship may just look into the minutes.
Every word, what's wrong in that?
My lord, your lordship may
the
look into the
most-
minutes. My lord, your lordship may look into the minutes, page 99, my lord. Then your lordship will find the objections were raised before the minutes also, page 99. 99.
Ultimately, it was decided by majority.
After, my lord, through discussion, the last paragraph, after thorough discussion, such numbers of what commissioner has expressed their comments and views in front of the chairman regarding the matter of distribution of fund. Accordingly, once Partha Kumar Nath, what commissioner, ward number 1, has raised his views in the meeting as per the guidelines of 15th Finance Commission. The fund may be distributed in population base and it should be followed. In the meeting, both ex-officio members have raised their views, requested the chairman to take up the single scheme for matter draining. But where was the discussion? Where was the discussion?
Read next.
My lord, hence, the chairman has also informed the House that the united grants will equally distributed towards development work and requested all the members present in the meeting to submit scheme list of respective wards. And the said meeting such and such, the board be requested to prepare a plan of, this is for implementation of the plan. Hence, after overall discussion, the today meeting, it is unanimously resolved that the total fund of 15,500 doing such and such may be equally distributed, 1,000 only in each ward accordingly. Discussed and resolved that the monthly ordinary meeting may be convened, that is different. My only conviction, when the constitution provides, there should be a recommendation for the municipality boards to distribute. Even, my lord, in the municipality 243, why says the finance commissions will look into the matters, my lord? Article 243, why?
Yes.
My lord, because your lordship will find in 243 why also there the finance commission will say about the how the money to the local bodies has to be implemented. And the learned single judge, there is no recommendation at all. My lord, at least if there is no recommendation, at least the necessary party when he was before the learned single judge would have been given a notice to come and say that there is no recommendation, then my lord, the guidelines would prevail. If the learned single judge only because of the IA filed by the chairman and no other ward commissioners has come before the court, my lord, the chairman says, I will distribute it equally. That is why, my lord, the learned single judge has had dismissed this petition.
My lord, it is a actually case of my lord misunderstanding of the guidelines, my lord. Yes, actually they, my lord, misunderstood the guidelines. It is properly as per my lord, guidelines, my lord, in the meeting it was considered and found, my lord, his claim is not tenable, my lord. Because his claim is that, my lord, as per population, my lord, fund to be gone, my lord, which is otherwise, my lord, not possible and unreasonable also, my lord. How? Because, my lord, suppose one place, my lord, there are 5,000, my lord, in ward, my lord, and another, my lord, 5,500, my lord. His claim is that, my lord, 5,500 should get, my lord, more money than, my lord, 5,000, my lord.
That is what the guideline is.
My lord, but guideline.
Distribute the funds as per the ratio of the population.
No, my lord, as per guideline, my lord, it was, my lord, it is ward wise, my lord, not population wise. It is page 60. Page 60, my lord.
Yes.
Page 60, it is provided that, my lord, it is should be done, my lord, as per, my lord, ward wise, my lord.
Which para you have?
B, my lord.
B.
B, my lord. First paragraph, my lord.
First paragraph, yes, B.
Yes, yes, my lord. For the
urban-
urban local bodies, other than the, my lord, million plus cities, the grant shall be distributed to each, my lord, urban local body on the basis of accepted recommendation of the latest State Finance Commission suitably modified to accommodate the cantonment board, my lord. There all in case the non-availability of the SFC recommendation for distribution within a particular category, the allocation should be on the basis of population and area in ratio of 9.10. The state should be make allotment grants on population basis to the cantonment board. Name and other details of the cantonment board are provided in annexure so and so of the finance so and so report. Some cities and towns may be part of some urban agglomeration, but they will still receive the grant under this component as million plus cities challenge fund in the additionality in the case, my lord. Now, my lord, findings of the honorable single judge, my lord. In this regard, my lord, page 116, my lord. Paragraph 29, 116. In the case on hand, the Hailakandi Municipal Board in a democratic manner in a special meeting of its ward commission chairman and other invitees member having arrived at a unanimous conclusion that the fund are to be distributed equally among each of the wards in the considered view of the court that the said decision cannot be held to be an erroneous one and or arrived at a violation of the provision of the Assam Municipal Act 1956.
Yes.
Obliged.
Item 18.
Lord, I have been served a copy of the appeal today. I stand for the sole respondent. My lord, 18.
You are for the private.
Private respondent, lordship will have it after a week, my lord. I've just received a copy of the appeal.
Okay, Mr. Private respondent. Sole respondent.
Sole respondent.
Sole respondent has submitted that he is in receipt of the copy of the appeal today itself. He takes some time to complete his inspections.
A week's time. A week could do, my lord.
10 days.
Obliged.
Item 19.
May please, your lordship. Lordship, kindly matter may be adjourned for the day, lordship. My senior has some personal difficulty, lord.
What's in the matter?
The matter is, lordship petitioner is in possession of land in question, lordship, since his predecessor in interest. And land advisory committee also approved the settlement proposal of the petitioner, lordship. Subsequently, circle officer issued eviction notice challenging which the petitioner filed repetition, lordship. And that repetition was disposed of, dismissed, lordship, filed order, include order dated 13/9/24, page 93.
So the stand of the state is not entitled for settlement.
Lordship, their stand is that land in question is a water body. And
That's a pond.
Lordship.
So how can it be settled in your favor?
And subsequently, land advisory committee also cancelled the proposal that is done.
What's wrong with that? Means the land where you sought settlement is a land recorded as a pond, whether it can be settled.
Lordship, my senior may be heard, lordship.
Pass over for the time being, call your senior.
Yes.
Item 20.
Yes.
Lordship, in this case, appellant challenge participate in the selection process. Lordship, and they are the unsuccessful candidate. They challenge the selection process on the two ground, Lordship, that they are not satisfied with the marks given in the written test as well as extracurricular activities. And they are not satisfied. Against that order, repetition preferred. Honorable Single Judge disposed the repetition.
Already granted you the relief.
On only one part, Lordship, and there is no finding that only regarding the written test.
If you will be able to get the 2 marks and able to achieve the cutoff marks, you will get the appointment.
Lordship, it is only for extracurricular activities part. But so far as written test part is, no decision was taken by the learners.
What do you mean by written test?
Lordship, kindly have a look at advertisement, Lordship. That is started from page 58, annexure 1, Lordship.
Page?
It started from page 58, annexure 1.
58.
Lordship. Lordship, kindly come to page 63. It started from page 58 and 40, from Lordship, page 63.
Yes, 63.
Lordship.
Yes.
B clause number B, Lordship. Written test will be consist of 80 multiple choice type question to be answered by tick marks. For each correct answer, the candidate will get half a marks. The standard of the test shall be of class 8. Total marks for the written test will be 40. There will be no negative marking. However, no marks will be awarded if candidate ticks 2 or more options or tries to change the answer after putting tick marks. So there is a 40 marks for the written test, Lordship, and extracurricular activities, Lordship. Kindly have a look at next page, page 64.
Yeah, read.
Lordship. A breakup of the marks awarded for extracurricular activities and special skill, which is a maximum 40 marks, shall be as follows. Experience as homeguards, 1 year experience will earn 1 marks in each qualifying year. Those who have completed advanced training will be awarded 2 extra marks. Total marks will not exceed 10 marks. Experience as SPO will earn 2 marks for each qualifying 1 year. It will not exceed 10 marks. Computer knowledge, 6 month duration, 2 marks, 1 year or more duration, 5 marks. State level sports, represented district or inter-district competition or state level competition, 2 marks. National level sport, person who has participated in national sport even as a part of a state contingent recognized by the Indian Olympic Association, 5 marks. Marks for additional educational qualification. So, Lordship, this part was decided by the Honorable Single Judge, but so far as written test part, that was not decided.
What was your objection?
Lordship, marks there that was given to the petitioner, they are not satisfied. It is less, Lordship.
That can't be a ground until and unless you make out a case that written marks given by so and so are not correct. You are not satisfied. That can't be the reason to interfere with the order.
Lordship, they made an RTI application for supply of the answer sheet, but that was also not supplied.
But then ultimately, how will simply on your statement that you are not satisfied, therefore you interfere with this?
Lordship,
you may not be satisfied. That doesn't mean that we should interfere in this.
Lordship, may I pray for calling of the record, Lordship, of the written test?
There is no question of record, sir.
Lord,
First of all, you demonstrate, you prima facie satisfy us. And where you argued before the learned single judge, the primary contention was only this.
Lordship.
That these extracurricular or this SOP marks that has not been granted, learned single judge has granted.
Lordship, page 56, prayer in the writ petition.
Prayer, yes.
Page 56, Lordship.
Yes.
Written test and extracurricular.
Page number?
56, Lordship.
Yeah.
In the prayer portion.
Read.
Written test and extracurricular activities thereby include their name in the select list.
Appoint the petitioner to give appropriate marks in written test extracurricular, thereby include their name in the select list. So, how this, where is the government in the petition?
Lordship,
That, this.
Lordship, that is it, para, Lordship.
Verification, final select list. Then the petitioner begs to state, petitioner begs to say petitioner obtained 13 marks, 19 marks, and 12 marks in extracurricular activities. Also, the petitioner obtained in the written test so and so. So the petitioner begs to state that.
There are 5 of the
Additionally allowed
read petition, Lordship 50.
Beg to state the written test was arbitrarily, for which authority did not supply the result sheet. Exemption begs to state that the marks in different types of tests, extracurricular so and so. So what is the foundation? The para number 9 is the only
Lordship, it is 5 also, there are 5.
5.3.
Only statement, Lordship, otherwise no document as
yes,
such.
we read.
Lordship, they were impressed that they would be selected as they done well in the written test, and the petitioner further state that marks were given arbitrarily, for which they were unsuccessful. In the meantime, they made an application under RTI.
Arbitrarily, how this marks were given arbitrarily, what is the arbitrariness you have to show?
But Lordship, how they can prove? They have answered it.
They can't prove, then we can take simply on your statement that the marks have been given arbitrarily. Therefore, we should deem that yes, there is arbitrariness. There must be some foundation, sir. In para 5, they were impression that they would be selected, they done well in the written test. So everybody is having impression that I am doing very good and therefore I should get the desired result. That is not possible, sir, in each and every case.
Lordship, may I one thing prefer call for the record, Lordship. That will be
Sir, at least you should, at least.
except statement, there is nothing. Except statement, there is no other.
On this basis, sir, we can't.
That is true.
Yes, this writ appeal is referred on behalf of finance being agreed with the order dated 10/2024 passed by the learned single judge and writ petition number 4534/2023. Stop. A bunch of writ petitions were filed before the learned single judge, primarily raising a grievance that the respondents have not followed the uniform pattern in allotting marks for the period of services rendered either as home guards or special police officers while conducting the recruitment for the post of constable under the Assam Industrial Security Force. The learned single judge, after hearing the counsel for the parties and on the basis of the consensus arrived at between the counsel for the parties, has disposed of the writ petitions with the direction that the cases of the writ petitioners are liable to be considered by allotting 2 marks for such each certificate within a period of service either as home guards or SOP. And if it is found that the petitioners are within zone of consideration and have secured more marks than the cutoff marks secured by the last appointee candidate, the benefit of appointment should be given to them. As a matter of fact, learned single judge has directed the respondents to revisit the result of the recruitment while taking into consideration the certificates submitted by the petitioners regarding their experience while working as home guard or SOPs. SOPs, would stop. Learned concept of the petitioner has submitted that it was also argued before the learned single judge that the respondents have evaluated the marks of the written test in arbitrary manner. However, the learned single judge has not given any finding on the said aspect. Stop. We have gone through the averments made in the writ petition and found that a very vague statement is made on behalf of the petitioners that the respondents have evaluated the marks of the written test arbitrarily. Full stop. No proof or any no proof of arbitrariness, even prima facie, has been produced by the petitioners before the learned single judge in support of their contention that the respondents have evaluated the marks of the written test in arbitrary manner. Good stop. On such vague allegations, no relief can be granted. So on such vague allegations, no relief can be granted, and we don't find any merit in this writ appeal. The same is therefore dismissed.
Apply.
Item 41.
Well, that's similar.
Already handed over a copy.
Day before yesterday, we have passed an order or?
Yesterday also.
Where is that order?
Well, the
Yesterday's order.
order copy is not with me. This is writable 393. Yesterday's order.
Check it.
Well, this is the order of 25/11, my lord. 25/11, my lord.
Same appellant.
Similar order, lord.
Similar order, I understand, but we have passed an order yesterday, taking into consideration this order, that order is to be passed. Supply the copy.
No. No.
Give me the copy. Wait.
No. Yes. Hold on. For 1 to 4, I'm in. Hold on.
Item 23.
May it please, your lordship. My lord, as your lordship has gone through the judgment, I take your lordship.
Yes, sir.
My lord, as your lordship has gone through the judgment, I take your lordship to the some terms and condition in the NIT, my lord. My lord, page 38.
Yeah.
The NIT starts at page 35.
Yeah.
My lord, I will take your lordship to page 38 first.
Yes.
Online mode of submission of tender paper, fee, bid security, technical bid, financial bid is mandatory. Manual submission of financial bid will not be accepted. These online things we have done it, madam. That was our part.
No.
6, we have on 6 clause, the bidder must submit hard copies in original on the following documents on or before 5/11/24 up to 2 p.m. without which the bid will be rejected. That is 14 hours. And these are the things. And next 8 is this, my lord. In case if any bund falls in any sequence will be held in the next working day. And the next page, my lord.
one falls in any sequence.
My lord. The next working day. My lord, they had provided a relaxation, and at page 39, your lordship will find. Page 39, 9 and 10, opening of technical bid 511, such and such, opening of financial bid to be intimated later. So it will be intimated letter. Financial bids date has not been given. And in the note, they have said, number 2, dates of serial number 9 and 10 in the above table are tentative. In case of any holiday falls in any sequence, next working day will be considered. My lord, only thing that, my lord, other than 2 p.m., I reached at 5 p.m. My lord, that was the act of God.
What was the fault of the respondents? You show us.
My lord, I am only saying, my lord.
Then how can we
Because
that on
at least your lordship may
they
say
have
that on that
rejected
day,
your technical bid.
my lord,
It's unfortunate. You should have planned your journey in advance.
because from there only thing is that there is no flight, my lord, from Hailakandi. I have to come by railway, my lord. Only thing there is a derailment on the middle of the road. That
is not within the that is an unavoidable circumstances for you as well as the respondents.
Well, there nobody will be prejudiced because I only don't want to give myself a contender. Only thing that I may be participating.
Nobody will be prejudiced. How if there are 4 participants or the 9 participants are out of these 3 or 4
My lord,
have not
if
been able to pass, then certainly the other
with all my lord, with all humility, I can just place before your lordship is well aware of that G.J. Fernandez versus State of Karnataka.
How writ can be issued in such matters where there is no fault?
Well, at least, my lord, on that, because next 6, 7, 8 years of holiday, immediately I file a representation. At least that I am entitled to know what is the result out of it. That, my lord, that much, I think, my lord, if they could give a reason for it, my lord.
It's a reason. They have simply said it was very specifically made clear
And-
that if that hard copy would not be filed by 2 p.m., it is liable to be rejected. That's all.
Another aspect of the matter, my lord, at page 35, schemes are not yet sanctioned by the competent authority. In the event of non-sanction of the schemes, the bid may be cancelled and no claim whatsoever on this account shall be entertained from the bidder.
Page 35.
35, and it is type copy is at page 34. Place inviting notice tender.
Yeah.
Schemes are not yet sanctioned by the 3rd paragraph by the competent authority. In the event of non-sanction of the scheme, the bids may be cancelled and no claim whatsoever account will be entertained from the bidders.
So how it is going?
Well, because here it is neither it is sanctioned, no financial bid date has
Then
given.
why are you worrying? Even though if some persons have filed their bid, even it is not sanctioned, then be happy with it.
My lord, page 39, at least they have said on that day that was tentative. Page 39, opening of that, it was tentative. For them also, my lord, they themselves have said opening of the technical bids was tentative. It was not a fixed date. My lord, at least, my lord,
Ultimately, even though the opening of this financial bid is tentative, date of the opening of the financial bid is tentative. There is a specific clause in the
Clause 6.
terms and conditions that if not filed, would be.
Only thing, my lord, I reached at
rejected.
5 p.m. In place of.
It's a hard case, but.
But at least when your lordship has said it's a hard case, my lord, at least.
Many cases are in hard cases also. The court, even though if they want, they can't.
My lord, and the hard copies are the which are already been submitted in the.
Then there must be some purpose for having this. Otherwise, you may challenge that earlier also that this condition when we are already filing this online copies, where is the necessity of hard copy?
My lord, that will be challenging a policy, my lord. Very nice.
When the policy is there.
But only thing at this moment, my representations may be. My representations may be disposed of, my lord. My representation, at least they may dispose of my representation. That much, my lord, will be my maybe satisfaction, my lord. That much.
Will grant them, will grant you the liberty or will direct them.
No, we have filed a representation. We have filed it.
Withdraw this appeal, will grant you the liberty, or if the representation is already filed and not decided yet, will grant them time to decide.
My lord, that much. That will do. That will do.
After attempting to argue the matter for quite some time in all these 3 matters, sir.
All these 3 matters.
23, 24, and 25. After attention to arguing matter for, arguing the writ appeal for quite some time on merit, counsel for the appellants has submitted that the appellants would be satisfied if a direction be issued to the respondents to consider and decide their representation filed
On received on 12/11, page 47.
same, all the.
All the three. All of
Dated,
dated received on 12/11/24.
uh, filed and received by the respondents on 21,
12/11, madam.
12/11/2024. Strictly in accordance with law, expedition. Full stop. In view of the above, these writ petitions are dismissed as not placed or withdrawn, whatever.
But if your lordship may give that word dispose without giving me a dismissal. My lord, dismissal.
So if we give this dispose of and if we give this dismiss, then how
Yeah, your
the
lordship may-
direction, the direction is for consideration of your representation.
At least the writ appeal may be closed, my lord. The word closed will give it.
Don't be so technical. Dismissed as not pressed. However, the respondents are directed to consider and decide the representation filed on behalf of the appellants and received by the respondents on 12/11/2024. Strictly in accordance with law, expeditiously, preferably within a period of 4 weeks from the date of production of certified copy of this.
If not already disposed of.
If not already disposed of, one line, dispose of, if already not disposed of, comma. within a period of-
Item 26.
May I please, Lordship? Lordship, this petition is filed against the order of the learned Central Administrative Tribunal, Lordship. The learned tribunal has directed to regularize and appoint the present respondents, Lordship.
This act casual laborers the opportunity to submit an application for enlistment in live supplementary
Casual
labor
labor,
register.
Yes, Lordship.
So even though if a person who was ex-casual labor and has not submitted application,
Lordship, screening committee was constituted and on scrutiny, Lordship, it was found that these respondents were never been in the live or casual, never in the engagement of the railway, Lordship.
how this tribunal has dealt with this? That even though if they have not registered themselves.
Lordship, tribunal earlier decision has relied on the earlier decision where the screening committee report was not accepted by the tribunal, Lordship. And earlier, Lordship, since 2002, Lordship, these matters are continuing, Lordship.
So in the earlier matter, what happened in that earlier matter? Have you challenged that earlier order of?
Earlier order, Lordship, not direct order to regularize, Lordship, it was to constitute the screening committee. Once the screening committee submit reports, then this again challenge the Lordship in another way. After that, again, the consideration order was passed. Again, Lordship, this in this way, Lordship, since 2002. And also, Lordship, after Lordship, Umadibi's case, this regulation order authority have passed, Lordship. Because they were never in engagement of the railways. Not once, Lordship, 2-3 times, Lordship, screening committee was constituted.
Order dated 20th of July 2020 is, where is that order?
Page, Lordship, 95. This order was also passed pursuant to the Honorable Tribunal's order.
They were in the service up to which date?
Lordship,
These applicants were in service up to which date?
Lordship, for 3-4 months as per their
A particular period.
period, Lordship, no, it's a case, Lordship. They have submitted some casual labor card, Lordship, though it was not found bona fide authentic, Lordship. Page 79 onwards, Lordship.
Date.
Did not the same date, Lordship.
Okay, then they.
Like in 79, page 79, he was engaged from 12/11/1987 to 31/12/88. For
So that this whatever whatever the circular of the railway that was applicable in relation to those persons.
Yes, Lordship.
Those ex-casual laborers who were in service on 1189 and later
81.
discharged, but they were given an opportunity to submit an application on 31st of March 1997. The persons who are already in service of 31st of March 1987, how they were supposed to apply in this?
Lordship, their names were not included in the roll of casual labor, first of all. And secondly, Lordship, this is.
Admittedly, if they were working up to.
Lordship, there is no record of their serving as casual labor during this period, Lordship, and railway. Thus, all the records have been scrutinized, Lordship. Their names are not.
You objected their claim in the OA?
Yes, Lordship.
I was saying what?
Lordship, on repeated scrutiny of the matters, Lordship, it was found that there is no records available in the railway, Lordship, regarding their engagement as casual labor during, they claim that they were engaged during 86 to 88 period, Lordship. There is no records of their engagement in the railway, first of all, Lordship. And secondly, they have not submitted any application as per the notification for their regulation.
Application required to be filed in relation to those employees whose services were terminated prior to 31st of March 1987.
But our case is that they were not in the role of the casual labor of the railway, Lordship, at any point of time. Though they have submitted during hearing, Lordship, some casual labor card, Lordship, and it was in the forensic laboratory, it was found that the signature was not Lordship, original of the officer. So authenticity of this casual labor cards are also disputed.
No, it's learning concept of the Recruitment has submitted that the tribunal has not been added, directing the respondents to regularize the services of the respondents. So though no proof is available on record to suggest that the respondents were employed as ex-casual labor casual laborers in the railways. And the council has submitted that the tribunal has altogether ignored that for the ex-casual laborers were required to file an application, were required to submit application for their enlistment in live/supplementary casual labor register by 31st of March 1987. But but none of the respondent has said application. It is submitted that the tribunal has allowed the OA and the OA filed by the respondent and directed issued a direction for regularization of the service on the basis of the earlier order passed by the tribunal in another OA without even discussing, without even holding that the petitioners, that the respondents were engaged as casual laborers with the railway at the relevant time. Issue notice of step application. How many respondents are there?
123, Lordship.
How you will get them served?
Lordship.
Altogether are they different?
Lordship, paper publication.
Huh?
Paper publication, Lordship, because
Publication on the first day.
Lordship 123 and whether they were in the
Registered AD and Dusty.
Lordship.
Returnable 8 weeks.
And there is also Lordship for stay of the order, Lordship, because 4 months time was granted to regularize this.
The date of the order was?
14, Lordship, 14/6/24.
Or the time is already over.
Lordship, since it is pending.
The meantime, take an operation of the interim order passed by the court shall be listed till the next date.
That's it. Obliged.
Pass over meter 10.
Lordship, my lord, apart from our submissions, it is apparent that they have misguided the honorable court, my lord. They have misguided because they said that it's a forest land or proposed forest land. But we filed the RTA application and it is seen the deputy district administration has clearly said that there is no such thing. Can you say?
That's altogether different thing. What about this?
That is,
Contempt, willful disobedience.
I'm submitting my, I'm satisfying your lordships. Now, lordships, they are clear statement was that. So in that view, they have misguided the honorable court. Secondly, my lord,
We have
notice was
taken care of that. Despite whatever they stand, we have made it clear that without ascertaining whether this land is proposed reserve forest or reserve forest, they can't proceed further. That is what the direction is.
Yes.
Despite their whatever stand.
Not done, my lord,
If they have tried to mislead the court, we have, the court has not been, the court has, they have failed to mislead the court, sir.
It appears so because there is not a word written by the district administrator that the case, the land falls within reserve forest or proposed forest.
Sir, ultimately, what's the order, sir? Kindly read.
The other things, lordship, this is a revenue village. Yes, I understand.
It's simply, you're trying to rack up the issue which has already been disposed of by the learned single judge as well as division bench, sir. On merits, we can't go into the this contempt.
Yes, sir.
You just
No,
see
I only,
operative order.
well, I only wanted to show your lordship's kindly look that they did not come with clear hands. That is my prayer was there.
Now that writ appeal, writ petition and writ appeal are over. Now,
Over.
here you have filed this contempt petition.
Contempt
We
petition.
are exercising contempt jurisdiction.
My lord.
We have to see whether the respondents have willfully disobeyed the order of this court or not.
Yes.
And for that, prima facie, you have to satisfy.
Yes,
us.
my lord. First thing, my lord, the order of the honorable court,
Yes.
that it is must be carried out both letter and spirit.
Sir,
In that view, I am
kindly
reading.
read the order.
In that view, page 103, my lord.
Let's read the order together.
103, my lord.
Yes.
Operative portion 103. Having heard the learned counsel for the appellants and after taking into consideration the impugned judgment that is 2-24 passed by learned single judge in WBC number so and so, as well as the materials placed on record, we make it clear that though the learned single judge had opined that there is no illegality in the notice dated 6/12/2017, but had also made clear that forest authorities can only exercise its jurisdiction in RF and PRF lands and not in respect of revenue lands. We hereby clarify that before taking any actions against the appellants or similarly situated persons, pursuant to the notice that is 6/12/2017, the forest authorities are required to ascertain that the lands so occupied by the appellants or similarly situated persons falls within RF or PRF lands, and after ascertaining the same, the forest authorities can take any action against only those persons who have illegally occupied the RF or PRF lands. With the above objection, it will be disposed of. Now, my lord, this order your lordships passed on 24/9/2024. An order was, my lord, communicated. Thereafter, neither jointly they did not make any attempt to measure the lands, whether forest land or not. Only verbally they are saying, you go from here, otherwise.
Verbally, you can't take into consideration, but until and unless there is some proof.
Well, they do not write any.
Whether they have
There are
dispossessed-
notice, my lord.
Whether they have dispossessed you, whether they have dispossessed you,
My lord, kindly see 107, my lord.
107.
Yes. They are noticed. They do not write any name, my lord. Only in a conspicuous place, in a tree or in a house, the notice, kindly see what is 107, notice. This is hereby informed that the persons who have been residing in the Paikan Reserve Forest that in view of the order dated 5/9/22 passed in so moto PL number so and so by the Honorable Guwahati High Court and the power vested under Assam Forest Act that 1891, an eviction drive will be conducted very soon in the Paikan Reserve Forest. Therefore, it is requested to all the families who have been residing in the Paikan Reserve Forest to left the Paikan Reserve Forest along with their dwelling houses and utensils. Now, Lordship.
So,
now, my lord, our apprehension, Lordship, kindly consider, we are living there with our everything, our family.
in apprehension, contempt petition can't be.
I think, but
Until
they,
and unless you show us there is a willful disobedience of the order of the court.
my lord,
we take action.
Lordship directed them to conduct joint survey.
We have
That is not done.
directed them. We have not directed them. We have simply issued a direction that pursuant to the notice, eviction notice issued to the parties, any person, the respondent authorities are obliged to ascertain whether it's a forest land or
Yes,
reserve forest land.
my lord, yes.
So,
But now, my lord, but when they are saying you vacate the land,
where is that, sir?
that is not there, but they do not issue.
Then it is not a case of contempt, sir. Until and unless you show us that without ascertaining they have taken any action, you show us.
But action will be taken one day, everything will be finished one day. My lord,
Ultimately, Mr. Advocate,
Mahmood,
the contempt, you are supposed to inform or bring into the notice of the court that this is the contempt.
Yes.
Ultimately, it is the court. If they feel that the contempt is made out, we'll take action. If we don't feel that there is no contempt, and that is for us. If any person is
I understand
alleging
that, my lord.
something or something saying, until and unless we feel, okay, yes, we have been disobeyed, then only we can do. We don't find any such.
I understand, but in the practice, my lord, in practice, we are in passing this, they come one day with bulldozer and demolishes the houses. There is no time for us.
That is also over with the Supreme Court judgment. Latest Supreme Court judgment, that is also over.
But my lord, every day they are saying, whether you have vacated. So,
Anyway, agree if a person comes and threatens
My lord,
you without there
my
being
lord,
any
my lord,
authority,
my lord,
why to worry about it?
my lord, with folded hand, may I seek some kind of order that they do not.
Some kind of order, not in contempt petition, sir. We have a very limited jurisdiction to look into it.
Yes, that is true.
Then how can we pass any order in this contempt petition?
But they are Paigan. It is not Paigan. It is adjudication. They have changed the name also.
Whatever it is, we don't find any that there is any contempt of the court.
Microphone also, my lord, they also use microphone over the area that you vacate the land anytime. So this type of, how can we?
Ignore that without ascertaining whether it's a reserve forest or proposed reserve forest, they take any action, come, we'll see to it. Many times, even though they're roaming around in their loudspeaker, ignore it.
In that view, Lordship may kindly close down this.
Mean by sir, that view, where we are simply.
My lord, we are in read jurisdiction. Read court has ample power, my lord.
Sir, at least read court while exercising contempt jurisdiction has a very limited.
Contempt is also part of read jurisdiction. However, my lord.
So that is on the wrong premise. That is not.
It is a byproduct of the writs order.
What do you mean by byproduct? It's not something we are showing and it's a byproduct is coming. It is not the.
My lord, I leave it to Lordship some relief if possible.
Sir, if you are agreeing, then where is the point to argue?
I leave it to Lordship.
Then what to do?
My lord, I may be allowed to withdraw, and if any indication is found.
We are simply, that is always open for you. We are not passing any restraint order since you have filed, and if any contempt is there in the future, you will not be able to. Wants to withdraw, dismisses, withdraw.
And then, if the parties are agreed, that
is always open. Please keep this in mind. If certainly there is a contempt, we'll consider it. We'll not non-suit you on the ground that since you have earlier withdrawn this petition and now we are not going.
All right.
Pass over meter 19. Item 30. Item 19.
We'll pass over, otherwise we'll pass an order.
Yes, sir.
It's part order, non-prosecution will dismiss this petition. Inform the council. Nobody will appeal. Will dismiss the petition for non-prosecution.
Item 30.
Lordship, that's reflected in page 138 in the order. Lordship, kindly come to page 138.
138.
138, and that's reflected in the order. Paragraph 5.
Light and heavy duty vehicle.
They did not.
So they're possessing which certificate?
Yes, that license.
License of
Light and heavy vehicle.
light or heavy?
Light and heavy.
They were required to
Yes.
possess, but the applicant, the respondents were, the petitioners were possessing what license? What type of license?
No, they did not even submit, Lordship.
License they were not even submitted.
Now their contention is, since it was not there in the original advertisement. So that was not required to be submitted, but within the period, the corrigendum was issued and they were required to submit. And now they are challenging that since it was not there in the original ad, therefore.
Effective 20 something.
Yes, you are appearing for. Yes.
Item 31.
Affidavit not filed, my lord, in terms of. My lord, in this matter, we need some time, my lord. We have not received instructions, my lord. Some deliberations are going on in between the directorate and government, my lord, but proper instruction we have not received. So we have been inspected to obtain for some time.
You have to pay the amount.
Yes, my
The
lord.
court's order.
Yes, my lord. Original order.
Defy that.
No, original order we cannot defy. That's why, my lord, we need some time, my lord.
How much time? You pay they're simply 900 rupees and something. You have to pay.
But in total, the amount comes to a huge amount, my lord.
That is for, if the huge number of employees were there or whatever the laborers are there, you have to pay. You can't take the excuse, a huge number, therefore we are not going to pay. Then why you have engaged them?
Yes.
This can't be the excuse.
Yes, my lord. So some time may be granted, my lord.
How much?
My lord, 4 weeks time, my lord.
Otherwise, be ready. We are going to call the officer concerned. After 4 weeks, if the amount is not paid. These are the lowly paid employee. You can't. Look at this writ appeal is essentially filed by the appellants, raising a grievance that despite a positive order passed by this court in their favor, directing the respondents to clear their arrears of honorarium or what is it?
Honorarium.
900 per.
Honorarium or?
Honorarium.
Honorarium, my lord.
Honorarium. The respondents have failed to pay the same. And the council appearing for the state has frankly admitted that pursuant to the order passed by this court, the arrears of honorarium is required to be paid by the respondents, by respondent state. They submitted that the matter is under active consideration of the respondent state, and it is expected that the grievance of the appellants would be redressed at the earliest. Then it concept for the state plays some time. Time paid for is granted. However, it is expected that the respondent state shall clear the areas of the appellants as directed by this court, because taking into consideration clear the areas of the exam at the earliest as directed by this court, particularly taking into consideration that the appellants are the members of the lower strata of society and are being deprived their legal due, are being deprived from their legal entitlement for a long time, from a long time. Do it fast.
Obliged for that. May I pray for my lord fixing a date, first week of January.
Item 32.
Meets with your lordship.
What about the record?
Lordship, otherwise I have filed my affidavit, your lordship. I have filed my affidavit, your lordship.
What affidavit?
Lordship, the thing is that it is an admitted fact that the records of 2020, 21, 22, 23 are missing. Apart from, Lordship, the originals are missing. Xerox copies are available, Lordship.
Okay, Xerox copies are available.
Lordship.
You are verifying that these are the Xerox copies of the originals.
Yes, your lordship.
You are verifying.
Lordship, I verifying, Lordship, the thing is that I could not ascertain whether it's the original, it has been Xerox from the original or not, your lordship.
From this Xerox copies, what came out?
Lordship.
What is, whether these persons were attended the meetings or not attended?
Lordship, in fact, some names are there, but all the names are not available in the records, your lordship. That is the,
Some names are available.
apart from, lordship, apart from the private respondents, your lordship, their names were not reflected from the records, your lordship, in the initial of 2020, 21 and 22, 23. Your lordship.
So you mean to say that they have not attended the meeting?
Not attended, your lordship.
Your affidavit is there?
My affidavit is there. I have filed it on your lordship, 27/9/2024, your lordship.
We received the 18th of November.
Huh?
The copy was served on me on 18th of November.
19th of November. No.
Oh, that's all.
Your lordship,
November.
it's filed in the month of November, lordship. Sorry, lordship.
Nasiruddin Ahmed.
Nasiruddin Ahmed, yes, yes, your lordship. It's filed in the month of November. Lordship, in page number 192, your lordship, I have stated, if may I read it, your lordship. 93 is the relevant portion. 22, 23, 23, 24, those are available, lordship.
Then saying that on the basis of that, you're saying that this list, attendance list and everything is not available.
It's not available, Lordship.
So now how you are disclaiming that they will not attend with the meeting?
Lordship, they have sent me two of the Xerox sheet, but that doesn't, those records doesn't reveal, your Lordship. As
On
we,
one hand, you are saying that attendance register is not there.
attendance list is not available, Lordship.
So then how to ascertain whether the.
Lordship, that is the difficulty, your Lordship.
If my lord may permit me to address your lordship on this.
Clarify.
That is the difficulty, your Lordship, because without the original, we couldn't ascertain who attended the meeting. And
So then in the, how this finding of the permit signatures that they have not attended this or of the registrar, how it can become?
Lordship. Otherwise, Lordship, if your Lordship kindly takes up the impugned order which has been challenged in the writ petition. It has been
74.
page 73, your Lordship. Page 73 of the writ appeal, your Lordship.
Cooperative 74.
Operative portion is at page 74, your Lordship.
70.
The second paragraph, your Lordship. Page 74, second paragraph.
Read.
In the absence of the original proceeding books and attendance register of the year of 2020, 21, 21, 22, it cannot be ascertained whether the Xerox copy of the attendance register available with the petitioner is correct or the attendance register available in the office is correct. Because it is seen that some serial numbers in the attendance register present with the office are blank, whereas in some serial numbers has the name of the petitioner in the Xerox copy of the attendance register available with the petitioner. Now, it is not possible to ascertain without the original attendance register whether the said serial numbers were originally blank or were erased off while making a photocopy. Now, this is the finding of the register, your Lordship. As the petitioners were otherwise eligible to be elected as BOD of so-and-so society limited under section 37 and section 40, except for violation of section 40 within bracket 2, the violation of which could not be substantiated in the wake of absence of the original attendance register, the right of the petitioners to be member on the board cannot be curtailed. Yes. My lord, under the law, there's a requirement of attending 2 meetings out of the previous 5. The entire dispute is when admittedly the registrars are missing, how to ascertain whether they attended or not. They may have a say.
They
May have a say that if there is no basis of ascertaining, you cannot hold it against us, against them, I mean. But there's a requirement of law to be otherwise qualified. It is their admitted case, I repeat, admitted case, that the earlier 3 meetings they did not attend. Page 97 of their appeal.
Where is that?
Page 97. Page 97.
Okay, earlier 3 meetings they have not.
They did not attend. It's just 10.
Then what about this 2 meetings?
Even without these 2 meetings, if it is to like this, any out of the previous 5, if you attend, you are qualified. But what happens if in a row you don't attend 3? You attain a disqualification. That is section 23.
That you have not argued.
We have not argued. It's a point of law I'm addressing with the lordship. Absolutely. It's a, absolutely. Lordship will remand the matter back on that point. That's it. Lordship may be pleased to remand the matter
Why
back.
you should remand when you have not argued?
We are raising a point of law, my lord.
The point of law, where is the foundation for that? That you have, that these persons have not attended these 3
Foundation of-
meetings.
I am not,
And therefore, even though if it is assumed that they have attended those 2 meetings, then also.
we
they
cannot
are not
assume or
attended.
not assume the attendance, but there
And that
stand
was
is,
the- And that was the ground of cancellation.
my lordships,
That was the ground of rejection of their nomination. That
rejection
they
of
have not
nomination.
attended 3 consecutive meetings.
No, 2.
Out of 5 years, they have not attended 2 consecutive meetings. This is what the rejection order.
Rejection order says, from since last 2 things are not there, it cannot be ascertained. Therefore, election must go.
Sir, rejection of nomination was or not was on what ground?
Because earlier they had not attended and the 2 which they claim to attended, there is no materials on that. My lord.
Where is that order of rejection of nomination?
Nomination 65 is deferment, my lord, 65. 65 is a deferment order, my lord.
65 is the
Deferment order.
deferment order. What do you mean by that? The nomination rejection, that order.
My lord, it is in the charts. Absent, cancel, they have charts. Which charts would be starting from page 48. 48. Then
Yes.
C would be Jamiruddin Losco, that would be cancelled.
Huh?
C would stand for cancel, my lord.
C, okay, cancel.
Cancel.
Okay,
It is in this fashion, the matter, this will cancel.
so no ground.
It was cancelled on that ground. When the matters came up, it was contended by them in appeal that this is not the way you cancel, because we had not attended 3 meetings, but we had attended 2 meetings, of which the books were lost.
It shows the, and where is the order of the registrar?
Registrar's order, my lord, is at page 73, it starts. It cancels the election. But 65 will be the first in point of time when it came up.
Cooperative.
And at least attended to Jelly. Which section you was referring?
I was referring to section 23. Section 23 of the Act. It is 23(1)(f). Termination of membership, if I may read, my lord. The board may, by a resolution passed by 3/4 majority of the directors present and voting at a meeting held for the purpose, terminate the membership of a member if he, now I come to F, does not use the services of the cooperative society for a period of 3 years, or does not attend 3 consecutive AGMs, annual general meetings, or is to be a resident of the area of operation of the society. The middle one, 3 consecutive years they did not attend, is an admitted position by them.
This resolution of the board?
My lordships.
So where is the resolution of the board?
Because it was being run and managed by the officers concerned. The board could not hold a meeting earlier, therefore the board had resolved.
It is a requirement that the board has to pass a resolution.
If there is a board.
Certainly, before passing that resolution, opportunity of hearing is to be provided to the.
But page
You would have
97
shown that for this reason, or I have attended the.
No, they have not attended, they admitted it. It's on the other way around. It's a statement made by them, they have not
This
admitted.
is subject to the termination of membership by a board resolution passed.
But there is no board.
3/4 majority and directors present in the voting. Where is that?
Correct. They have attained the disqualification Because the board is not there, there cannot be a meeting. It was run by the officer of the society. But for two lost books, it cannot go this way, that way, my lord.
Okay, then again this.
Our nominations were never in the
So,
challenge.
I have not-
My lord.
Provided that no such resolution shall be passed without giving.
Absolutely.
Reasonable opportunity raised in the board meeting.
I'll put that question to myself, my lord.
Yes.
If I am that member and an opportunity is given, and I read page 97 of the writ appeal for a moment, which is their election application appeal,
Yeah.
page 97.
So you mean to say that since the facts
They
are
admitted
very
it.
clear, therefore there is no need for giving any
There
opportunity.
has to be given an opportunity provided there is a board.
But
There is no board.
that you can't take reports of that section.
No, I was projecting a case
Not
where,
then,
where two
have
missing.
you argued before the learned single till this point?
No,
Then, okay, now you raise this
but
point. sir.
two missing registers does not invalidate
Certain.
the elections. my lord.
certain. That is.
If my lord, two missing registers, if they claim to have done it,
And
which no one
ultimately,
picks,
what the, out of, how many nominations were filed for 15 posts?
27,
27.
27.
How many have been withdrawn
6 withdrawn,
and
10 rejected, 10,
10 rejected.
10
16
rejected, 60.
Out of, and 16 rejected, then 13 remain.
My lordship, two went, my lord,
Or for 15 posts, 13 nominations remain.
my lordships. They will be 10 in number. Nine remains. my lord. There will be 9 in number. Here is 7, my lord. But then we come,
But
if I,
new election, you get yourself elected.
if I may address your lordship, if I may address your lordship this way also. Suppose, just thinking it aloud, there's a re-election or a new election, fresh election. Even then, the requirement of section 40 subsection 2 cannot be wished away.
Yeah.
There is no register, my
Give
lord.
the opportunity.
There is no register for those 5 years. Again, we are put to the same position, my lord.
You can't non-suit them on the ground that since the register are not available, it would be deemed that you have not attended those meetings. And
I'm not on that, my lord. Even the same difficulty would continue because for the next 5 years also, the registers are not there.
see, let the contingency come.
It has arrived, my lord.
It has arrived. No, we'll see in the next, whenever the next election will take place.
But so far as the writ appellant before your lordships are concerned, our nominations were never in the challenge. We had done no mischief. We attended the meetings, continued all the way.
That is not the requirement. Illegal nomination of in a case of illegal nomination, you are not supposed to challenge this, that your nomination was wrong or return candidate nomination was wrong.
So we are non-suited for no fault of us. That what I'm projecting is this.
That is there. So suppose in an election petition, if a person in a election for this MP and MLA or whatever member of legislature or parliament, if a person comes with the code that my nomination has wrongly been rejected, then what would be the effect? Or so and so nomination was wrongly rejected. If that is true, the whole election will go, sir.
Or there may be a way out without touching on the next 5 years because two registers are not there. If they agree to hold an election for the remaining number of posts, that can be done.
Remaining number of, how many remaining number of posts? 10?
No, not 10.
5 posts.
Two are gone, only 7 remain now. 7 plus 8 would be there. They are 9 in number. Otherwise, the register, the same logic would defeat itself, if I may say.
Let him do. Then demonstrate before him that even though if these attendants are not registered, they have not attended these 3 meetings and therefore they are not entitled. Let him decide.
That observation be there, I'll go with that. The liberty be there at least.
Why observation?
At least the liberty, my lord. Because lordship is sitting in appeal of the matters. This is the last court.
Liberty, this is the procedure, sir. In the nomination, always scrutiny is there. You can very well raise this objection.
Since we have addressed your lordships on this and it did not fall through, then otherwise again going back to an authority, my lord.
Again, it may create confusion. Just whatever the law permits, you may do. The election matters can't be. Take care. This is covered by. being agreed with the order dated 29/8/2024, passed by the learned single judge in writ petition number 7109/2023. In the said writ petition, the petition, 7/2/23, whereby the learned single judge has dismissed the writ petition referred on behalf of the appellants. Full stop. The appellants has approached the writ court, being agreed with the order dated 6/10/2023, passed by the
Registrar of Cooperative Society.
Registered Cooperative Societies.
Yes, my lord.
Registered Cooperative Societies, whereby the AGM of Mohanpur CS Cooperative Societies Limited held on 25/4/2023 was cancelled while exercising powers under section 40 in bracket 4 in bracket small Roman A of the Assam Cooperative Societies Act 2007. Full stop. The defect of the case are that election notification was published on 30th of January 2023 by the Assistant Registrar for conducting annual general meeting and election for constitution of the Board of Director of Mohanpur Sambai Samiti Limited, hereinafter to be referred as society. It is not in dispute that the total number of directors in the society is 15, and for the said 15 posts, 27 nominations were submitted by the shareholders of different categories such as weaker section, stronger section, women category, and SC/ST category. Out of those 27 nominations, 8 nominations uh, 10 nominations of different sections have been rejected, and 8 nominations were, how many? 8 were withdrawn.
It should be 9 accepted, 12 cancelled, 6 withdrawn.
12 cancelled, 12 were rejected, and 6
Withdrawn.
6 withdrawn,
Withdrawn.
and only how many accepted?
9.
9 were accepted against those 15 vacancies. Let's stop. The persons whose nominations were rejected have approached the registrar by way of filing an election petition alleging that their nominations have wrongly been rejected by invoking the power under section 40 of the Act of 2017 in the guise that they have not attended the 2 meetings of the AGM in the last 5 years. So stop. During the course of adjudication of the election petition, the registrar has recorded a finding that the attendance register of the AGMs pertaining to the year 2020-21 2021-22 was not available as the same was missing. And in the absence of any such record, it was not proper on the part of the presiding officer to cancel, to reject the nomination papers of 12 number of shareholders on the ground that they have not attended two consecutive meetings. Consecutive or what?
It would be consecutive because they say the earlier three they did not attend.
Just a, what is the exact word?
2 out of 5.
They have not attended two meetings out of the last 5 meetings. So the learned single judge, after taking into consideration the said facts and circumstances of the case, has dismissed the writ petition and has refused to interfere with the decision of the registrar dated 6/10/2023. While observing as under para number 12 or para number 11, say 13 and 17. 11 to 10. Having heard the learned counsel for the parties and after taking into consideration the material available on record, we are unable to take a different view as has been taken by the learned single judge, because the fact remains that the registers pertaining to year, that the record pertaining to the meetings for the years 2020, 21, 2021, 22 of the society is not is not available, and in the absence of it, in the absence of it, the decision of the nomination officer of rejecting the nomination papers of the 12 number of shareholders on the ground that they have not attended two meetings out of the last 5 meetings is arbitrary and erroneous. With these observations, this writ appeal is dismissed. In the initially with the consent of the counsel for the parties, the matter is heard finally at admission stage.
Okay, otherwise, the order of the learned single judge, 90 days time has been granted to conduct the press election.
Do
conduct.
Not. The respondents are now free to conduct the press elections as directed by the learned single judge within a period of
90 days.
now 60 days. For 90 days, there is
Yes,
a
sir.
procedure.
There's a procedure. Right? For one-man committee, it has to be conducted within 90 days. Right? If the one-man committee is running the society.
90 days from today.
Okay.
Participate in the election. If
We'll
you are popular enough, you will get elected.
We'll raise the objections they made. Obliged.
Item 33.
Please notice that since last so many days, That, on last so many days, none has appeared on behalf of the petitioner. Neither petitioner is present in person or none has appeared on behalf of the petitioner. The matter is adjourned for 4 weeks. However, it is made clear that if on the next date, the petitioner is not represented, either petitioner in person or through advocate, the matter would be decided on the basis of the pleadings available on record.
Item 34.
Here, they file affidavit, my lord. In this case, the affidavit is filed, my lord. Only this.
They have filed the affidavit.
Yes, my lord. So, my lord, may I pray less, my lord, they, when they fix for hearing, my lord, they are after.
Charge sheet.
Yes, my lord.
Simply because the inquiry officer has given the report that the charges are not proved.
Yes.
On this basis, you will file him a charge sheet.
My lord,
So
that is,
whatever the inquiry officer has to give a finding that the charges are proved despite there being no evidence.
my lord, my lord, the allegation is, my lord, yes, my lord, the basis is,
Whatever be heinous or
yes, my lord.
heinous,
My lord, they are only for the squad is a fact finding inquiry, my lord.
yes.
It was well, only the squad was appointed for the fact finding inquiry, only some facts. Well, it was not, but
Simply because
but
in his judgment, the inquiry officer has found that the charges are not proved.
yes,
This is a misconduct.
my lord, it was the allegation. Yes.
Misconduct. That is a misconduct.
I understand, but
It's a harassment purely.
yes, but I think it's-
Goes for audits.
right.
With the consent of the parties, the consent of the parties, the matter is heard. Finally, at admission stage.
Item 35.
Please will also, in this matter, I'm led by Senior Counsel Mr. Didas. He's on legs in court number 4. If it is not inconvenient.
Item 41 for hearing.
This has been listed after a long time, my lord. And
You're not prepared.
although the petition is with regard to, my lord, pursuant to Supreme Court direction, this was registered. But my lord, it was widened, the scope of the PIL has been widened. And if your lordships kindly have a look at the order dated 21/9/2023.
Yeah.
The states were directed to take steps.
Also appointing chairperson of the police commission. Mizoram, we hope and trust that the complete by the next date of list.
Yes,
Already
first,
appointed, Lordship. I have received the instruction.
First-
Lordship, on 5th of March 2024, Lordship.
and the first paragraph, it says steps to separate the crime investigation wing from law and order. So this code wanted that a separate crime investigation wing to be created and train them accordingly. That was the, my lord, but original PIL is, my lord, the subject matter is slightly different. Mhm. Hmm.
Itu yang kita akan.
Paragraph 7.
Mr. Das,
Yes.
but my knowledge is concerned. I think so, once either the law commission or something has also suggested this, that have a separate
Investigation.
wing and investigation wing and law and order wing.
Yes.
But ultimately, I think so this, government was not ready to accept that idea and they rejected in some manner.
Here also, my lord, there was government, so far as I remember, there was shortage of manpower. So existing, my lord, law and order personnel were trained in NEPA, police academy to create a special investigation. And they will do both, my lord. It's like that.
Like that, but ultimately, if the state government or the central government or the state government is not ready for this idea despite the suggestion by the law commission.
Yes. My lord, can have the affidavit filed on 2/9/2023. Government has filed an affidavit. Page,
Consider it in January.
lordship.
January.
If the government, my lord, comes up with the updated whatever is happened in this matter, then that will assist us. my lord.
Update whatever the.
Yes.
Nowadays also, the persons have been, personals have been identified and therefore they waiting for.
That for that purpose.
Much obliged.
Item 42.
May I please the lordship, lordship, in this case, lordship, if your lordship will, go to page number 42, your lordship will find that an relevant part is lordship, page number 55. The writ petitioner has challenged the selection process and also to set aside the appointment of all the private respondents which has been selected by the duly constituted selection committee, lordship, on 5/8/2010, lordship. And your lordship will find in the paragraph 4 of the judgment passed by the learned single judge, the counsel for the petitioner submitted that, lordship. Your lordship will find, may I read, lordship?
Yeah.
The petitioner counsel submits that calling letter was issued only to the respondent number 5 and 6 in respect of the 2 vacancies that were available for Dhuburi district. Accordingly, only the respondent number 5 and 6 have been selected and appointed to the said post. The petitioner counsel submits that no advertisement was issued prior to the selection process and as no calling letter was issued to the petitioner, the entire selection and appointment of the private respondent number 5 and 6 is be set aside as the same has been done in violation of Article 14 and 16 of the Constitution of India. Lordship, if your lordship will see page number 28, this is the minutes of the meeting after the interview has been conducted by the selection committee. Your lordship will find page number 28. How many candidates that were appeared in interview, lordship, from the Dhuburi district? Your lordship will find at page number 28, lordship, 31 numbers of candidates that were appeared, lordship. So far the petitioner's part is concerned, lordship, the appellant, belongs to SC category, lordship. And this part, the writ petitioner is not also a SC candidate, lordship. If your lordship will see page number 30, lordship.
He can't even apply for those posts, the petitioner.
Yes, if he is not this post, he can apply.
Who is appearing here for the petitioner?
Lordship.
Who is appearing for the petitioners? Who have filed the petition?
Lordship, he has not appeared today. He is not now.
Item 43.
Lord, this is my petition.
Just a minute, ma'am.
Yes.
Lordship, may kindly adjourn the matter for today, Lordship.
So why, when you have already informed the other side, why you have not mentioned it in the morning? You should have mentioned the counsel appearing for the VC has said that there was they informed her that they'll get the matter adjourned and in the morning you have not, nobody is there on your behalf.
Yes.
Once you have informed the other council, then why to keep him waiting for that or her waiting? Now, what do you want?
Lordship may kindly adjourn the matter for today.
On which date?
Lordship, 12th December.
Yes, ma'am.
My lord, can we have it in January 20th? I'm just.
January 20th.
Yes, my lord, if it's convenient and my learned friend may not take a date, I may come physically if possible.
Okay, learned counsel for the petitioner, learned counsel for the respondent, please. For adjournment. Why, what's the ground?
He is in bereavement, Lordship. As Mr. S. Datta supposed to argue the matter.
As
he
the
is in
counsel for the
bereavement.
respondent is in bereavement. Stop. Learned counsel appearing for the petitioner has submitted that a fixed date may be given. Full stop. In view of the above, let the matter is adjourned for 20th of for 20th of January 2025.
Obliged, Lordship.
Lord, my friends may not ask for adjournment on that date.
Ma'am,
If
on
it
that
is
day,
reasonable.
on that day, if situation such as today is
Yes,
there.
no.
Can be
That
said.
is the exceptional thing.
Yes.
So,
So we'll keep this in mind.
grateful.
Yes.
Pass over method 19.
Obliged.
Tuesday. Let's take on Tuesday. Yes, Mr. Das.
Yes, the one matter was there, but since I'm sorry, Malay, it was adjourned because I was in court number
Which
4.
one? Which?
It's item number 35, my lord.
We have been called, but nobody.
I'm sorry, my lord. I'm extremely sorry
Okay,
for
wait.
that. Your logic is next it.
Whatever date you want.
Done.